Hello, I'm Dr. Daria Shirakova, the founder of Houston Place of Arbitration, and today we have the second webinar of our new series called All Roads Lead to Houston. In this series, we invite the prominent and well-known legal practitioners to discuss with them different topics which are up to date. And today our guest is José Antonio Moreno Rodríguez, who is a well-known arbitrator and also partner at Altra Legal in Paraguay. And Jose Antonio is a very, very well-known expert in investment contracts and investment arbitration. He did a lecture on private and public international law and investment arbitration at the Hague Academy of International Law, which is a great achievement. So we will discuss today a very, very interesting topic, which is called Investing in Certainty, Shaping the Future of International Investment Contracts and Arbitration. And at some point during today's webinar, we hope also to see Rocco Palma, who is the legal officer at UNIDROIT. But now I will start asking Jose questions because he didn't come here to listen to me, but to listen to Jose Antonio. So, Jose Antonio, can you tell us a little bit about yourself, how you started being interested in arbitration and investment law, and also, do you know anything about Houston at all?
Hello, Daria. Thank you very much. It's an honor to be here with you today. And I disagree with you. You have lots of things to say about the topic I'm gonna speak today about. But yes, I've been working for many years in international contracts and investment arbitration. And since my years of studying my pursuing my LLM degree in the United States, I had a very renowned professor in international investments law. He was Vice Dean David Smith of Harvard University, and he introduced me with passion to this topic that I really like a lot. Um, I am a practicing attorney and also an arbitrator. I arbitrate at exit cases. I'm a member of the PCA Arbitration Court. I was a member of the ICC Arbitration Court. I'm also a member of the TAS Sports Tribunal. And so I've been very active also arbitrating in international commercial and investment and sports related cases. That's a little bit about my background. And regarding Houston, no, I've never been to Houston. You have to invite me to Houston.
You're
Uh,
invited. You're
I've
invited for
been,
sure.
yeah, I've been near there in Dallas, and I'm that is a pending matter for me. I really have to be there.
You could have come for the World Cup, but I guess now it's a little bit late. But let's go back to our topic. So you suggested that the title of our discussion be Investing in Certainty. So what kind of uncertainty are you concerned the most today? Is it regarding applicable law or contract interpretation or the outcomes of arbitration or something else probably?
Well, matters related to investment law, if there's an investment law topic or subject or a subtopic, matters related to 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 to, to this subject, they are at crossroad today because um, there's criticism about diverging case law in high stakes arbitration cases, and also lots of criticisms to arbitration as a mechanism to solving this type of disputes on the one hand. And and that has been a major discussion until recently, and only in the last couple of years or 3 years, um, something different has been brought to the spotlight, and that is the discussion of the absence of a corpus that regulates comprehensively matters of international investment law. So, of course, you have problems with the arbitration mechanism, and those problems have been addressed by ICSID, by the ICC, by UNCITRAL in all their efforts for reform the arbitration regime, and I think they have been quite successful in advancing very effective rules to address many of the concerns. But that is only part of the problem. The other major problem that you have here is the absence of a comprehensive corpus, if you wish, that regulates appropriately the several issues that may come about in international investments and also in the international investment arbitration setting. So that is where we are at the crossroads. And why did things change in the last couple of years or 3 years? Because until now, you saw no light since the 1920s. You have seen several efforts to have a comprehensive regulation of matters related to international investment law. Many projects, the Harvard draft, the Havana Charter, the OECD efforts, and all of them failed. But now we are trying something different. Now we're trying to not have an international regulation of the matter, but have instead appropriate contracts in place that can contemplate the main issues that usually arise in this international arbitration setting and that are not dealt with in regulation. So that is what is changing now. Now we are seeing that, and I'm going to comment about it in a short while. Now we are seeing a project from UNIDROIT and the ICC Institute of World Business Law that is attempting to put forward a model clauses and also principles so that the matters that could not be addressed in an international regulation or code or whatever could be now appropriately dealt with in international investment contracts.
So thank you so much, Jose Antonio. You explained why now is the right moment to revisit international investment contracts. Could you please, in our discussions previously on this topic and in some of your presentations, you highlighted that investment arbitration has traditionally focused on treaty standards and public international law. And so while many disputes actually arise from contractual relationships, so do you think that it's the society and the arbitration community went too far towards the public law and there should be more place for private international law in this space?
I think yes, the answer is yes. I think that has a historical explanation. The early oil cases of the 1950s and the 1960s, 1970s, they frequently invoked Article 38 of the International Court of Justice statute regarding the general principles of law. And that created an understanding that public international law was the law governing international investment contracts. But if you look at those cases closely, you will see that what the arbitrators did in those cases was use Article 38 of the International Court of Justice statute to introduce general principles of law, but not in reference to public international law, but to issues of private law that usually arise in the international investment context. These tribunals did not have regulation of the several matters that could arise in the investment relationships. And so they had to deal with issues such as force majeure, issues such as damages, such as interest, such as liquidated damages or penalty clauses. And for all these matters, they did not find solutions in many underdeveloped legal systems. So what they did was look for general principles of law. They used the Article 38 of the International Court of Justice statute, but they not use it to achieve a public international law result, if I may call it this way, but to look for private law solutions to private law matters that arise in the international investment setting. So of course, if there are violations of public international law, if there's arbitrariness of the state, if minimum standards of treatment are violated, yes, there you have a public international law issue. But usually you have a private law issue arising in international investment contracts. And if you take a look at the origins of the ICCIT Convention, you will see that the ICCIT Convention was envisaged to deal with mainly contracts, international contracts. Of course, also treaties, but what the drafters of the convention had in mind was mostly contracts that were around at the time and that needed a good dispute settlement mechanism, and that is why ICCIT was created. Only after was that also treaties started to generate investment arbitration cases. But that was a development that was perhaps not envisaged by the drafters of the ICCIT Convention.
So, do you think that public international law really doesn't provide a comprehensive body of rules for the contractual issues? And what kind of problems does this create for tribunals sitting in these investment disputes?
No, public international law it's a relatively new discipline in the history of law. You know, it was in the late Middle Ages, and then with Grosio, Gentili, Vittoria, and other scholars who sculpted a new discipline trying to justify the 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 investment relationships of colonial powers in the colonies. So what these scholars did was try to create a system of public international law that did not exist. And in doing so, they used private law. This is very well explained by Hirsch Lauterbach and others who have dealt with this historical, who have studied the historical traces of public international law. And what you had in this, what they were trying to do is justification for several matters, such as damages, such as matters related to property law, matters related to interest, matters, all culpa and fault, all issues that in the end are private law issues. And so they incorporated that to their public international law in creation scholar scheme, right? And that on the one hand. On the other hand, you had these claims commissions solving issues of international investments. You had the Jay Treaty of 1791. Then you have the friendship and navigation treaties. All of them dealing with international investment, but in a very modest way. You did not have there at these treaties. You did not have there a comprehensive regulation. You don't have there a corpus, nothing. And so when these claims commissions had to deal with all these investment relationship issues, then they used the scholarship that was there, and that scholarship was invoking notions of private law. the issues that typically arise in a contractual relationship of private law, in a property relationship of private law. And so in the end, you have doctrine, you have scholarly writings addressing several issues of public international law, but doing so from really from a private law perspective. And that is why public international law never became well equipped to deal with issues that arise in international contracts. And that is what we have until today.
Thank you. Just one last general big question before we go to UNIDROIT exactly and its principles. So I've recently read a very interesting article by Stratos Pahis, who was analyzing the quantity of contract-based disputes in ICCT arbitration, actually on the ICCT side. So, and he proved that there are a lot more contract-based disputes than the purely treaty-based disputes. So it seems, as you also highlighted, that many investment treaty disputes originate in a contract. So do you think that tribunals adequately appreciate the contractual dimensions of these disputes, or do you think they sometimes just overlook these issues in favor of treaty analysis?
Many tribunals, of course, they deal appropriately with contractual issues in the international investment setting. But then you also have cases in which there have been tribunals have overstepped and applied public international law to private law matters. For instance, the abuse of the FET of the when tribunals one of the derivations of FET, the FET standard, is that you have to take into account the legitimate expectations of the parties. And when tribunals use treaties to rewrite what the parties have written in their contract, using as an excuse the FET or the legitimate expectations, then they are overstepping because what more legitimate expectations of the parties that what they wrote in their contract? So that generates an issue. Of course, if there is if there's arbitrariness in the act of state or whatever, then yes, public international law must step in, because to put it in a private law terminology, an international investment contract is an international contract, and as all international contracts, the contract governs. Everything that's written there governs, unless the relevant public policy applicable is violated. And when you are in an international investment setting, the relevant international public policy applicable, of course, is public international law. Public international law is public policy. So it supersedes what the contract says. But usually there's no public international law in discussion. There's no arbitrariness of state in the discussion. There's no expropriation in the discussion. It's just an issue of currency. It's just an issue of expectation, damages. It's just an issue of formation. So those are all private law issues. And of course, we're going to talk a little bit about more about this when we address the new project. But I really want to thank, because I'm seeing here Rocco Palma. Rocco Palma is a brilliant member of the UNIDROIT secretariat, and he has been very actively involved in the UNIDROIT ICC project that we're going to comment about in a few moments. And so he's the appropriate voice of speaking about this very relevant project when we go into it.
Thank you. And welcome, Rocco. I also presented you at the beginning of the webinar, so we were all waiting for your appearance.
Yeah, it was my fault because of the time. I said to him that this would be at 3 p.m. Rome time, and it was 4 p.m. to Rome time. So, but now he's here. Thank you,
We
Rocco, for
apologize and
this
happy that you're
additional.
here. So for those who don't know, FET is fair and equitable treatment, if we have some students who are not that familiar with this term yet. So as we have Rocco now here, let's go straight to the UNIDROIT principles. So why are UNIDROIT principles suited for international investment contracts? Could you please both explain?
Okay, let me start, and then I'll ask Rocco to complement. Um, the UNIDRAW ICC project, and Rocco can enhance my introduction. This has been a project ongoing for, I think, about 3 years, Rocco, since 2022, I think. And yes, and it takes advantage of the best of two worlds. UNIDRAW, that's a centenary. It's this year it's 100th anniversary, and a very prestigious university worldwide. You know, in Asia, in Africa, in the Americas, in Europe, and so it has advanced many instruments that have been very successful. Of course, the UNIDROIT principles on international investment contracts. You have the Cape Town Convention and all its protocols, and many other instruments that have been very successful. So you have the prestige of this international organization on the one hand, and then you have the ICC, the International Chamber of Commerce. That's more than 40 million companies that are members of the ICC. Then you have a presence in more than 130 countries. And ICC has been promoting the use of several standard form contracts. And in this matter, it has been very successful in areas such as sales, such as distribution contracts, turnkey contracts, and many others. The ICC model contracts are very much used, and of course, this can be explained because of the ICC reach and the ICC effectiveness in practice. So you have the best of both worlds: the academic, the international organization world of UNIDRAW, and the world of practice of the ICC. And these two organizations joined forces for this project. And what is the idea here? Well, let me use the word probably never have a comprehensive corpus of a regulation of international investment law matters. But yes, you can have something different. You can have a soft law instrument such as the UNIDROIT principles of international investment contracts adapted to the international investment law setting, taking into account that most of the matters of the international investment relationships are private law matters. So then you can have here a soft law instrument that could interplay with model clauses. These model clauses can use the UNIDROIT principles as applicable law if you have regulation that authorizes the use of soft law as applicable law. But even if you don't, you can have these model clauses. And in the domain of contract law, what you have in your contract usually supersedes the suppletive norms of civil codes or of private contract law regulation. So in the end, you have your relationship regulated and governed by all these detailed clauses that have been elaborated in the last 3 years by these two organizations. What UNIDROIT and the ICC did was form a working group comprised of many of the leading scholars in the topic, many of the leading arbitrators, experts of public international law, private international law, arbitration experts, contract law experts, experts in public law issues, environmental, human rights, etc. I think Rocco will confirm this or not. I think it's the largest working group in the history of UNIDROIT. It has been very effective with lots of meetings. That on the one hand. Then also you have there a consultative committee. I have the honor of preside this committee. It is a committee that, as the project advances, makes consultations with the states. So you have the input of states, and this also gives a strong legitimacy to the work that we are doing. So that is how we came now to this process, and Rocco will make the announcement soon of what happened today, and it's something very relevant in this regard. So that is where we are now. Rocco, I don't know if you could explain. One thing that I don't want to forget, this is not the first endeavor of UNIDROIT in international investment law. UNIDROIT has already advanced a legal guide on agricultural land and investment contracts. It is a very well-praised instrument in prestigious circles of the world, academic circles, because it has demonstrated how the UNIDROIT principles of international commercial contracts can interplay effectively with international investment law issues, and how in the end many of the matters that arise in international investment setting are private law matters. And again, these private law matters are addressed appropriately in a very well rounded and prestigious instruments such as the UNIDROIT principles. So, Rocco, then I give the floor to you. Maybe you can tell a little bit more about the instrument of UNIDROIT, how many parts it has, what does it contemplate, and what happened today?
Yeah, sure. Thank you for the invitation. Well, I would say first that let me say that I am a now I'm a principal legal officer since few months, but I'm an Italian lawyer, then diplomat of the Ministry of Foreign Affairs, and then seconded to UNIDROIT from 4 years and until the next year. Working with the former president, Professor Managuti, with Ignazio Tirado, Anna Veneziano, and the colleague Mirte Thyssen on this very wonderful project, which was the reason why I was seconded to UNIDROIT, because that was my bachelor thesis and one of my lines of research. 2015, I was in the Sustainable Investment Conference of CCSI, Earth Institute, Jeffrey Sachs, and UNCTAD, discussing exactly the reform of international investment treaties. And my position was exactly that would have been complete if we didn't have a reform of investment contracts, so providing certainty to investment contracts. Now, what I want to say is that today, these instruments are taken shape in its final provisional version, because exactly at midday Rome time, it was published on our website for the public consultation. As Jose mentioned before, the strength in UNIDROIT is in the academic practice expertise, which is used by the experts of the working groups. Is very different from other international organizations. They are not state delegates. They are experts that decide in their science and conscience, lawyers for lawyers and operators. And this is the great advantage, comparative advantage with other international organizations, because all decisions are based on expertise. All decisions are not driven by political opportunity but just by technical reasons. Also taking into account, of course, the interest at stake in the area. Then we had the consultative committee, which was chaired by Jose, so the voice of states is included. However, today we have a further milestone, because we are going to have a general consultation with all stakeholders at large, including industry associations, including any type of non-governmental organizations, which were in any case represented by the IISD, the International Institute for Sustainable Development, in the working group, multilateral development banks, even though Asian Development Bank had the chance in preview to provide comments. So we are really going to reach all the academic think tank thinkers that can give contribution to improve the instruments, which has taken its shape, its framework, and has already been judged as importantly complete by many stakeholders. That's a milestone, and the consultation will run until mid-September, let's say 14 September. And so we are keen on receiving comments, contribution, and if you can spread this news, it's very important for us to have the widest as possible consultation in a way that by interaction, by contribution, by cross-checkings, we can come to the best instrument possible. I'm gonna go back to your question concerning the appropriateness of the UNIDROIT principles to deal with the international investment contract, to say that the UNIDROIT principle for international commercial contracts, so private to private, it's a statement of principles of general contract law. So the UNIDROIT principle, it's a soft law which restates the American way, I would say, the way in a way which is neutral in between common law and civil law, which restate the essential principles of international of general contract law, reflecting mainly those transactional principles which are shared by all legal orders, which are well established beyond technicalities or the technicalities to which they are applied in each single national legal order, and with some best rules which are being considered by the experts most appropriate for international trade. What's the meaning? What's the purpose of the UNIDROIT principle? To provide clarity, predictability in international contracting. Each trader would like to apply his law. This is a neutral law, which is well recognized, which has commentary. So you have a provision, a principle, then a commentary. And this is clarifying the meaning and is reflecting mainly the way all the systems deal with force majeure, with good faith, with several principles, with remedies, with validity, with formation of contract. So this is important because it creates a common horizon, a common, let's say, legal discourse that can be explored and used by the parties in full knowledge. Let's think that if there is a contract between an Italian contractor and the Chinese contractor, then who would know the Chinese law? Who would know in Italy? Who would know the Italian law in China? Well, China has taken the UNIDROIT principle as a model for reforming its civil code in 2016, and is using a lot the UNIDROIT principle in order to create a general contract law framework in its legal order. Now, what we did with this instrument, the UNIDROIT principles, UNIDROIT ICC principles for international investment contracts, we took the UNIDROIT principles, and for all the reasons that Professor Moreno José was mentioning before, we tried to adapt principles taught for traders, for private to private contracts, to the specificities of investment contracting, where a state, a public party, is involved, or a state entity. So what we did is to see how the public nature of the party, the importance, normally long-term feature of the contract, but also the relevant public interest involved, would impact on the principles. And what we did is basically go principle by principle and adapt, including this instrument, only those principles which needed adaptation, referring back to the UNIDROIT principle as they are for what we thought, for what the working group thought, that was basically already suitable for producing a law for investment contract. This means that when if form is oral in the UNIDROIT principle for commercial contracts, in the investment principles, we need a written form. If there is an issue of legal capacity in the commercial contracts, which is not so relevant as in investment contracting, there we have much more important elements and principles and rules to consider, because there is an impact of mandatory law in in the state, in contracted state, or there is an issue of capacity to sign and to bind the state. Of course, in all these cases, I just mentioned two examples, we needed to have an adaptation, and we needed to comment this adaptation. In all those cases where we didn't think, the working group didn't think that was needed adaptation, we simply refer back to the UPIC as they are, the principle for international commercial contracts, and we provided commentary in order to explain how the principle as they are would apply to investment contracting. And of course, the model clauses also complete the picture and gives certainty to investment contracting. Of course, this gives clarity, this gives predictability.
No, if I may step in for a moment, because perhaps some people of your audience are not well aware of the UNIDROIT principles. They are a uniform law. They are like a regulation of international contracts of all of the general part of the matters of formation, of rights and obligations, of termination, of damages. You have a comprehensive regulation of this general part of contracts. And what UNIDROIT did with this is have like articles in a civil code, articles, then you have comments, then you have examples in many cases. And what this instrument does is it leaves most of the matters of international contracting and investment setting are also governed by this general UNIDROIT principle of international commercial contracts. But then the instrument that we're dealing with now has some adaptations that Rocco well explained. So, and Rocco, just one last question, because I think the idea of Daria is to have more like a ping pong of questions and answers. But can you explain a little bit the parts of the instrument, what the instrument in concrete deals with in its several parts?
So what I was mentioning is that in this way the principles of investment contracts, the ICC principle of investment contract, they provide, as you mentioned, a general contractual framework for investment contracting, adapted to the specificity of investment contract, and it includes, of course, several parts. Let's say that we identify since the first issues paper 3 layers content, 3 layers. So the first layer is exactly, let's say two. A big layer of contents, a circle of principle, which is exactly general contract law. So it's the UNIDROIT principles for commercial contracts as adapted to contracts with a state is party, a state entity is party. And this gives this general framework of principle which Jose was mentioning, which always lacked in investment contracting. And it was already applied even by treaty arbitration. So we in the issues paper, we identified a lot of cases where, in order to calculate the interests, even for compensation under a treaty, under FET, under expropriation, under a VAT, there was a lack of elements in international law, and then the UNIDROIT instrument, the UNIDROIT principle were taken as a standard. Now, in this case, we have directly for investment contracting and non-treaty cases, we have, of course, a general framework which gives all this clarity and predictability to the operators. But then we have a second layer, second and third, or a second which we could divide in two, let's say. And this is important because since by the mandate, the purpose of the project was to see whether the UNIDROIT principle can provide a general framework for investment contracting, but also try to address the big issues that concern, let's say, treaty law, including investment protections and sustainability issues, but from a contractual angle. So the idea was, let's see how we could provide in these instruments a kind of a set of provisions functionally reproducing the protection in investment treaties without being international law. So how can we provide a contractual envelope, a contractual protection to which contractual remedies are as attached, so rights and obligation, And in case of breach, in case of non-performance, we say UNIDROIT, because we use neutral language. So we don't want to charge, the breach with the meaning of breach in certain systems. We use non-performance. In case of performance, which remedies we can provide. So if the UNIDROIT principle provides remedies, and in fact, we refer back to in chapter 7 to that, for rights and obligation, we try to functionally reproduce investment protection. We needed to develop all another type of set of principles. And indeed, this second layer, which is incorporated in the instruments in chapter 5, rights and obligation, is not general contract law, but it's special investment law. So what we have in chapter 5 and also 6 is a set of investor protections, a general principles on performance and good faith, these obligations. And then we have, of course, a standard on expropriation. We have a standard on payments and transfers. We have standards on state cooperation and assistance. While on the other side, on the side of sustainability, we address these new tendencies in treaties to consider more investors' obligations, but just inviting states. The BIT is a treaty between two states. And one state invites the other to impose investors' obligation to the investors coming to invest in that in its country. In some cases, very few BITs, they use more peremptory language. They directly address investors, but it's very rare. But still, it's very vague, very generic. So this is why the instruments, the project wanted to address functionally sustainability obligation, but also investor protection to give more teeth, to give more specificity to these general standards that we have in treaties through a contractual language, which has to be totally and separately, independently and separately interpreted compared to treaties. On sustainability, what we did, we had not only in chapter 5, but also in chapter 3, where we have a pre-contractual due diligence, we have the obligation of the investor, with the assistance of the state, to consider an impact assessment and provide a management plan of the impact of the investment, to consider the inclusion and incorporation of the voice of indigenous people, indigenous population, to consider the impact in the investment area and in the neighboring areas, and to develop a set of obligations to be implementing throughout the investment. A general principle of sustainable investing is placed in the general part, and it invites the parties to identify what is the sustainability standard to be included in their contract. It's not, let's say, a peremptory standard, but it is ambitious. It invites to identify, but the party will identify it, international law, national law, whatever the stricter, based on their experience, based on the size of the project, on its scalability, on the real impact. So it's flexible. So it's something which the parties can shape without having, prescribed what to do. It's not so prescriptive. But the parties can refer to international instruments from international organizations, from multilateral development banks, and integrate through this reference in the contract the sustainability due diligence process. Then chapter 5 turns this into contractual, not pre-contractual or pre-commencement, pre-operation obligation, but in contractual obligations. So we have a set of model clauses on sustainability obligations concerning the environment, concerning social and labor standards, concerning community development agreements. So signing agreements with local community in order to provide them with assistance, rights, and voice in the consideration of the impact of the investment, or giving contribution to local community as a compensation for the impact, of course, that the investment can have. We, of course, follow the international standards in this area.
Rocco, sorry if I interrupt you. Thank you for explaining very well how the UNIDROIT new project will fill the gaps which the investment law and investment treaties leave. And also you touched upon the relationships with the indigenous communities, economic and regulatory challenges. I have a very, very precise question. There's an opinion in the legal community, which deals with investment contracts, that stabilization clauses nowadays are one of the best ways for the investors to deal with, the problems they can encounter with the states. That stabilization clauses, they are more adaptable than the general principles of international law and other types of application of international law in these types of contracts. So, but how can you challenge the stabilization clauses use and replace it more by the UNIDROIT principles? Are there any mechanisms that can facilitate adaptation and renegotiations and kind of go away from the idea of freezing stabilization clauses?
I just want to stress what Rocco has been doing until now is telling what the different parts of the instrument have in there. So as you can see, the instrument is very rich. It's very I think Rocco, you only got to chapter 5 in your introduction. You have 8 chapters, and you have, of course, stabilization, you have hardship, you have force majeure, then you have damages, you have so you have most of the issues that usually arise in this setting and that are usually not dealt with in other instruments. You will have these issues addressed in this international investment contract if you adopt the model clauses that this project is proposing. And in regards to stabilization, as Rocco will explain, this is one of the matters. As I said before, most of the issues of the UNIDROIT principle of international commercial contracts remain untouched because those are principles applicable in general to private law, and private law is applicable in general in the international investment arbitration setting. But then there are exceptions. There are issues that really are specific of this area, and stabilization is precisely one of them. Go ahead, Rocco, please.
Yeah. I just want to say that the first layer or circle of principle, which I mentioned before, so principle of general contracts, will correspond to a number of chapters. Chapter 1, so we have the functions of the instruments. Chapter 2 is the general principles of an investment contract. And then we have Chapter 3 with formation, Chapter 4 with validity. They reproduce the entire life cycle of a contract in accordance with the UNIDROIT principle for commercial contracts. Then, of course, Chapter 5, it's in rights and obligation, and this was what I mentioned that goes beyond general contract law. Chapter 6 includes stabilization, change of circumstances, but also some contractual principles, so hardship and force majeure, general contract principles. And then Chapter 7 is a remedy. So it's again, I would say 1, 2, 3, 4, partly 6, and Chapter 7 are basically general contract law, so these general frameworks. And then Chapter 8 is instrumental to the application of the instrument because it's about choice of law and, of course, dispute settlement, very important. Going back to stabilization, I was just mentioning the investors' protections in Chapter 5 and then the investors' obligation on sustainability. But Chapter 6 includes under the chapeau, under the umbrella concept of change of circumstances together with hardship and force majeure, a stabilization principle. I was the founder and coordinator of the task force from Roma Tre University and UNIDROIT on international investment contracts, and we produced a memorandum which provided a lot of model clauses, taking them from current contracts of the last 10 years. And as you mentioned, what we found is that stabilization clauses are more and more turning into renegotiation clauses. So the principle is called, in line with this memorandum with international investment contracting practice, stabilization and renegotiation, which can lead to adaptation. The idea was that if the parties, so the principle says, if the parties find it appropriate, so this is not strictly necessary, but if the party find it appropriate, with full awareness of the consequences, they can decide to negotiate a stabilization and readaptation clause. Which are the models which were taken? So, I mean, in line with the evolution of practice, the idea is to go for the economic equilibrium model. So the idea that if there is any change in law, including jurisprudential change or administrative decrees, that impact the economic equilibrium and reduce the economic returns for the investor during the life of the contract, based on a certain procedure, the investor can notify and provide evidence of the reduction of the economic equilibrium, of the economic return of the investment expected at the moment the contract was signed, and taking into account eventual changes. And then at that moment, it triggered a renegotiation. This should bring to reconstitute a balance, economic balance, which can up and through several measures, which normally are measures which can adapt the contract, the percentage of distribution of revenues, connected contracts, or eventually even extend the contracts in a way that reduced economic returns are reincorporated. The instrument, the principle, goes also for a limited fiscal freezing clause. So it was held that certain fiscal stabilization clauses, even though they touch on the fiscal sovereignty of the states, that a lot of states still use fiscal freezing clause. And we also found clear indication in many reports from international organizations, including from the High Commissioner for Human Rights, that still fiscal freezing clause can be important in order to favor flows on investment. So there is a limited space also for limited fiscal freezing clause. And of course, in case the parties do not come to an agreement during negotiation for the readaptation, there is an issue of arbitration. The parties here can, this is a soft law instrument, can decide how to shape their contract and which are the remedies in case the stabilization clause is breached. But of course, in case of a limited fiscal freezing clause, there is an issue of compensating the difference in economic return based on a fiscal calculation. There is, of course, also an exception, and then I finish, an exception which tries to incorporate also the concern for sustainability and for public policy, which we have in recent investment law and arbitration landscape. So there is an exception, meaning that it's excluded from the scope of the stabilization clause, be either a readaptation clause, a renegotiation clause based on economic equilibrium, or a limited fiscal clause, where the state has taken measure in furtherance of international obligation concerning the human rights, environmental, and social issues. Of course, this may be very large, so the parties are given again leeway and guidance in order to clarify beyond doubt how this exception is shaped. But it was clear in the works of the experts that this would exclude, of course, arbitrability, while the parties can still negotiate some solution in order to reconstitute the economic equilibrium also in these cases.
Daria, just one word. I know we have only 5 minutes, but this is a perfect example of an issue in which the working group attempted to reach a balance between positions of full stabilization, a freezing clause, and finding a middle way that is workable and that can be a solution acceptable in the international investment scenario. So this is a perfect example. Daria, you have a fantastic network of scholars and practitioners, and maybe you can help us in this consultation process. And of course, we are looking forward to receiving the comments. I know Professor Vos has been sending already some comments, and I'm looking forward to really engaging with him in these final stages. We have to benefit from all the wisdom that he has, he and many other people I know, Daria, that can really help, because this is still a work in progress. And that is one of the greatest strengths of UNIDROIT. That is, it really involves people. So in the end, its products are really a collective work and not a work just doing for walls of a group of academics, but it's really a joint endeavor. So thank you very much for this invitation, for being here, and I look forward to having another opportunity to seeing you again in this fantastic space.